Good afternoon, Ellen.
Hello, how are you?
I am fine. Miss Dean caught up with you?
Yeah, she did. I spoke with her yesterday.
Okay, all right. So you'll take it on Saturday.
Yes, ma'am.
Okay. So I'll just mention to the other students that some persons weren't able to take the exam on the day we had agreed. And so you'll get your grades next week, Tuesday. So yeah, so that's what I tell them. All right. So we're gonna do some teaching before we begin. So let's wait on the rest of them. I know it's the day of the storm, so I don't know how many people will actually attend class tonight. So let's wait a couple minutes for them. It's only 6:29. Okay.
Okay.
Oh, know what you could do, Ellen, while you're waiting? Pull out the cake that I sent you all called Whitlaw versus
Yes,
Morris.
I have it.
Okay, all right. We're gonna go over that.
If it's your storm, it's our storm. And we'll fix.
Recording.
Good evening.
Good evening.
Good evening.
Evening.
How are you?
Fine, thank you. And yourself?
Oh, I'm fine. You ready for the storm? Or the rain, as I should say.
Ready or not? Yes, mom.
You had no choice, right?
Yes, mom.
Okay, let's do. You want to just wait 5 more minutes if anybody else is coming? Or you all want to start? No, you all have been home now from what time? 12 o'clock, 2 o'clock?
No, mom, we got to the
2 o'clock.
What you said, Sydney?
I said we was open, regular hours today.
Oh, okay, okay. Oh, all right. So you're trying to say you kind of tired. Hmm. Okay, so let's start with our housekeeping. So we could get started. If I am correct, you all can correct me. Today is our 10th class. We would have started on let me see, is it the 10th?
Yes, ma'am, I believe it is.
So we started on the 6th of September or the 13th?
The 13th was the first class.
I think the 13th.
Okay, so then we're on our
The 9th.
9th class. Okay. I trying to get the final exam date together now. So look at your calendars. What looks like a good day? You know, it's Christmas.
What are we looking for?
Our
For
exam,
exam?
our final exam date.
Class
Our
finish was,
last day of class will be November the 29th.
oh,
So you want a final on the 6th?
Yes, ma'am.
mhm,
You get it over with, right?
right, quick.
Okay, so put finals. Banking law. December the 6th. All right. Next point, did someone just join? Davisha. Davisha, you heard that just now?
That the final is on the 6th of December?
Yeah.
Yes, ma'am.
Okay. And remember, before we break for the midterm exam, I told you all that I would give you all a question,
Right.
each question for the final exam.
Mm.
I'm gonna dictate the question to you. You could tell me if you want it to be worth 20 points or 30 points. 30 points will mean that there's a lot of information you think you'll be putting into the research question, and you think it should be worth more. Or we could put it to 25 points. So this is the question. I'll just read it first, and then you can dictate it. Okay, with the digital era progressing rapidly, changing the banking landscape, discuss the rationale for the discontinuance of checks in the Bahamas. Reference may be made to other jurisdictions and use legislation where applicable. How does that sound?
Say it again?
No, I'm gonna say it where you can write it down, but
No, I just saying repeat it again so you could get it.
with the digital era progressing rapidly, changing the banking landscape, discuss the rationale for the discontinuance of checks in the Bahamas. Reference may be made to other jurisdictions. Use legislation where applicable.
You could push them for like 25, 30 points.
Okay, let's see others.
Let's say 25. That's
Okay, anybody else?
25 is good.
25 is good.
25 can work.
Okay, all right. So you know, You can find articles in the local dailies with the governor as he started the conversation. But if you actually do some research, you will see that this is not a new topic. So in your paper, you will actually have to talk about how the financial landscape is changing. And then discuss the rationale why the move is away from it. And when I say use legislation, other jurisdictions have already started to do this. And so there may be legislation we have to put in place. So I would expect that you would refer to it. So how that sounds? Good? I'm gonna send an
That's
email.
good.
Okay, I'm gonna send an email. Put the date of the final exam, and I'll also put this question. So everybody should be on one page. Some persons weren't able to attend the midterm exam on the day we had scheduled, and so they'll be taking it this week. And so all the grades will be given next week. I apologize, but I didn't want to give them a brand new exam because it would put them at a disadvantage because they would not have been able to have a review. So without giving any answers to any questions, how did you all feel? Good?
Not at all.
What? Who said not at all?
That was hard.
What? That is not true. How it got hard?
It wasn't what we expected, to be honest.
What? I did not change a single thing. How you could say that?
I think I guess like with certain cases, we really went over the ones that we referenced based on the homework assignments you would have received. So that was the ones geared more towards check processing, the pointer customer relationship and stuff. So the other ones, we really didn't take the time to analyze that well. So that came as a bit of a shock. And then the multiple choice was really, really different. Yeah, it was different.
Different. Well, I didn't look at them as it because, like I say, some people have to do it this week. And so when hold on. Oh, never mind. I don't want to comment. Let me put them back. All right. I'll see what I see on the weekend. All right. So we're narrowing down now. Let's go to, you sound so disappointed as you say. Anybody else felt disappointed? No, yes.
Very much so.
What?
Yes,
was
ma'am.
disappointed. I feel the same way as Sydney.
No, said it again. Said it again. It was muffled.
I feel the same way Sydney feels.
Really? I thought the
Yes.
exam.
I was depressed when I left.
Hold on, let me see something. 1, 2, 3, 4, 5, 6, 7, 8. 8 persons took the exam. Okay. That was Davisha just now.
I think that was with Caitlin.
Hold on, let me see.
Yes, ma'am. You got me?
Yeah, I haven't marked it yet, but I'm looking at what you submitted. Let me see something. Okay, so the first part A, I'm not gonna say what the question is because persons haven't taken it yet, but this is just the instruction. You just had to choose one contract law case. So did you find that difficult?
No, wasn't that part wasn't
Okay,
difficult.
that part, okay. So let me see, question 1, part A. Okay, so people answered that. I can't tell if it's right or wrong yet, because I haven't read it. Part A, question 2. Someone did part A, question 1. Okay, so everybody did. Oh, who is this? I know this person. Okay, I see what happened. Okay. Part A. Part 2. Okay. I trying to see where is it that. Okay, so part B, I said choose 3, and I gave you 5. Is that the part that y'all found difficult?
Um, for me personally, it was kind of difficult to choose between the 3, because I guess the comfortability with answering, the certain types of questions wasn't there for me. But mainly it was the multiple choice that was the most difficult, to be honest.
Oh, okay,
Yeah.
okay.
The
All
multiple
right.
choice is different.
Let's see. I see some people just put the.
And then, Ms. Archer, some of your multiple choice questions, they were like not multiple choice.
What you mean?
They didn't have any options. Like it was a statement or a question, and we had to answer it from,
Oh, you mean like, yeah,
from memory.
yeah. I see those. They were deliberate. And there's 4. There's 4 of those. Okay, I'll look and see. Once I get the last exam, so I'll look and see. But I mean, everybody seemed to have sent in full answers to the questions. I haven't seen any yet where people just put 2 lines. The multiple choice I'll look at afterwards, but part A and B.
Hopefully it's enough for everyone who takes the exam to get a passing grade.
If not, then you'll have a makeup exam.
I think that's fair.
Mm-hmm.
Yeah.
A makeup exam, a take-home makeup exam.
Oh yeah, I like that. Mhm.
Mm-hmm. Depends on the grades. But I warned you all about multiple choices, You want any of them on the final?
Not if they can be like that, I rather just the structured questions.
Does it look like you all answered the structured
Yeah, I
question?
prefer structured questions as well. You can keep the multiple choice.
Yeah,
I know.
I don't
I
fancy it.
always do, but students keep saying they want it.
Yeah, but the students who wanted it wasn't there.
That obviously. Obviously. I can see that. Yep. All right, let's go to our new chapter. Worry not. Like I say, if you don't get a good grade, then I'll write a makeup exam. So it's no need to stress. It's just that when it comes to the final exam, that's it. So don't worry yourself too much. All right, so let's talk about types of customers. So we all know in banking, there are types of customers. You have individuals, you have companies, you have partnerships, you have joint accounts, you have persons who exercise power of attorney over accounts, you have associations, clubs, charters. So there are many different types of accounts. And depend on the type of account, the requirements for KYC differs. But all in all, when it comes to account opening, the bank is looking to ensure that the customer due diligence as per their policies and procedures are being met. So in your notes, I would have given you the standard formalities, which is the account opening documentation. And then of course, establishing the identity of the proposed account holder, making sure you get the specimen signature, and all of the KYC documentation. Of course, you should point out to the customer their rights and their duties, and also explain to them the fees that they have to pay, and any other information that they need with regard to the operation of the products and services that are being offered to them. So you all know when a person becomes a customer. You know that by law now, based on the principles in contract law. So that we don't have to go over. Correct? Everybody knows when a person becomes a customer. Yes. So individual accounts. This is just someone walking in and wants an account. And of course, you know that the KYC requirements is as set out by the central bank, where some flexibility has been given, where you don't have to just present your passport. There are other documents that you can present in lieu of that. In some instances, banks would ask for the identity of the employer. It depends on the case and it depends on the bank. So remember what I was saying in some of the earlier classes we had? Yes, if you're dealing with a commercial bank, and in some instances, you don't go back to get a employment letter or a reference letter. But in other types of banks that we have here, those things are required. They will ask for an employment letter. They will ask for reference letters. And I'm sure if you work in customer support, you will see requests coming in where persons have requests for a bank reference. So there are times when a person is unable to carry out their own banking services, and they would have a lawyer execute a power of attorney. And that power of attorney authorizes them to operate on that individual account. Depends on what the clauses state within the power of attorney. So once someone signs as under a power of attorney, then an agency relationship happens. The customer is the principal, and the person carrying out the actions is the agent. They are acting on behalf of that individual. So whenever a person comes to carry out that client's instructions, the bank must carry it out in accordance to what the power of attorney states. Sometimes the power of attorney will state that the person can withdraw funds to pay my medical expenses or to pay my car insurance. It actually states what the person can withdraw funds for. Now, If an agent withdraw funds that is outside the scope of their authority, and remember the authority comes from the power of attorney, and they do so for their own benefit, of course, that is fraud. And if the bank permits it to happen, then the bank itself becomes liable. Because that means that you have an agent who has not followed the instructions of his principal, and you permitted that to happen without referring to the power of attorney to see what authority that they had to do. And in doing so, the bank then becomes a constructive trustee for the funds that were received by that agent. And remember, a constructive trustee operates by law. So it's not a trust like when someone creates a trust. It's not that kind of trust. It just arises by law, which means that when the funds come in to the bank is responsible for ensuring that that principal receives those funds and they are credited to the account. The power of attorney is a legal document. And in it, the responsibilities are stated in that document. In some instances, the responsibilities can be general. Like it just can say, this person is to pay all of my expenses while I am incapacitated. So that means it's for a particular point in time. While others, like I said earlier, stipulates point by point what that person can do. Whatever action an agent takes on behalf of that principal, the principal is bound by those actions. So that means that whatever that agent does in the name of that principal and is within his authority as per the power of attorney, then that principal is bound. Now, of course, the power that or the authority that is given to that agent can be terminated. And that can happen if the power of attorney is revoked. And that can happen in certain instances. The principal can give notice that he no longer requires that person to act as his agent, or the agent can do the same thing. I no longer wish to act as your agent. The principal may become mentally incapacitated, or the agent can become mentally incapacitated. Now, remember, when you're talking about termination of the agreement, think back to contract law and the elements of a valid contract. And you will see that those same elements are now coming up in banking law. A power of attorney can also be revoked or terminated if the purpose for which the power of attorney was drafted is completed. So let's just say this person is going to have a surgery performed. And they know that once they come out, they're going to be bedridden, maybe for 6 months. The doctors say possibly a year. Then they will have a power of attorney drawn up for 1 year and stipulate in that power of attorney what exactly they expect that agent to do on their behalf. Once that time period comes, then that arrangement is finished. The power of attorney is revoked. So the purpose is done. It can also be terminated if the principal or the agent dies. And as stated in contract law, the agency can be frustrated, which means that the agent cannot perform his obligations under the contract due to unforeseen circumstances beyond his control. And of course, the agent cannot carry out an act that is illegal. And lastly, if the principal is insolvent, then of course he cannot carry out his duties. So an individual account holder is terminated, account is terminated upon notice by the bank of his death, mental incapacity, or reasonable notice by the bank to terminate that relationship, the banker-customer relationship. And remember, that was the argument in the case of Maurice versus Scotiabank. Having reasonable notice to terminate the banker-customer contract. Because remember, I said that reasonable notice is based upon the customer and the nature of that customer's business. So obviously, if you have a power of attorney, you have your responsibilities. If you exceed those authority, then of course, you are personally liable to that third party. And the same way, if an agent draws checks on the principal, and then he endorses those checks to the principal, and then he pays them into his own account, he again is personally liable. And of course, as always, the bank always puts themselves in a position of being liable if the staff do not carry out the checks and balances and ask the correct questions. Similarly, if an agent overdraws an account without permission, then of course, again, he is personally liable. Any questions? Now we turn to joint accounts. Joint account is an account opened by two or more persons, and it is different from a partnership account, even though the features are similar. So when you open a joint account, you have to be clear whether or not it is either or both. You also have to clearly state that any overdraft facility arising from the operation of the joint account is the responsibility of both joint account holders. So joint account holders are normally jointly and severally liable for any debts that must be clearly specified in the account opening documents. So joint and several liability gives the bank as creditor a right of action. And that right of action has to do with repayment of debt. The bank is able to set off the credit balance of one of the joint account holders' accounts against the debit balance of another account until it is paid off. The bank can also bring an action against the estate of the deceased joint account holder. If the bank has a right of action for debt on a joint account against the estate of a bankrupt joint account holder, it can also pursue that right against solvent parties on the joint account. Note that the bank's power as creditor is limited where there is a joint liability for the debt by joint account owners. Now, when it comes to joint account, one of the key things that you have to remember when it comes to joint account is survivorship. So where one of the holders of a joint account dies, the question always arises as to whether it is the surviving account holder or the deceased account holder's estate that is entitled to claim the deceased account holder's share of any balance standing to the credit of the joint account at his death. So what do you say? If there's a joint account, what happens to the funds when one person dies?
Can you repeat the question, please?
Where one of the holders of a joint account dies, the question arises as to whether it is the surviving account holder or the deceased account holder's estate that is entitled to claim the deceased account holder's share of any balance that stands to the credit of the joint account.
You're asking us which one is it?
Yeah,
I think that based on our procedures and policies with my bank, so the account it becomes the other person's account. So they have full access to that account after, or if the primary person is deceased, then the secondary person becomes the holder. So even if the deceased family were to get like a what's the thing called now, the probate, and that would become a court matter because of course the other person on the account would be the sole person for that account.
okay. Anybody else?
I agree with
I
Renzo.
say, I agree with that unless they have certain stipulations.
Okay, so let me see how I could word this so you could see there is a difference. The question when someone dies, and there is a dispute. The issue is not whether the surviving account holder or the deceased estate obtains a direct interest in the funds that stands to the credit of the account. Because the bank has the legal and the beneficial interest in the funds themselves at the time of the deposit. But it's really what rights they obtain to the choice in action that would entitle the deceased account holder to draw upon the credit balance and to instruct the bank to make payments from the joint account. Let's look at Whitlock. The case of Whitlock. So this is appeal from the Bahamas and is about the beneficial ownership of money held on a joint account at a bank. The account holders were Mr. Francis Leonard until his death in February 2010, and his friend, Mr. David Morey, who is a respondent to this appeal. The money in the account, which amounted to some $190,000 by the date of his death, was all contributed by Mr. Leonard, mainly, if not entirely, from an account previously in his sole name at the same bank, First Caribbean. The sole question in these proceedings is whether upon Mr. Leonard's death, the beneficial interest in the previously joint account passed to Mr. Morey by survivorship, or whether it formed part of Mr. Leonard's estate by reason of the operation of the equitable doctrine of presumed resulting trust, since Mr. Leonard had provided all the money. You understand the first paragraph?
So we're saying because Mr. Leonard contributed the majority of the money, I guess it would still be considered his, I guess.
That's the argument. So on the setting of the joint account in November 2009, both Mr. Leonard and Mr. Morey signed an account opening application in the bank's standard joint account form, which included the following provision: joint tenancy. Unless otherwise agreed in writing, all money which is now or may later be credited to the account, including all interest, is our joint property with the right of survivorship. That means that if one of us dies, all money in the account automatically becomes the property of the other account holders. In order to make this legally effective, we each assign such money to the other account holder or the others jointly if there is more than one other account holder. So at the heart of this appeal lies two questions. Does clause 20 deal with the beneficial ownership of the joint account, or merely with the bare legal title to the choice and action against the bank represented by the account? And the second question, is the fact that Mr. Leonard and Mr. Morey opened the joint account by means of a signed written application containing clause 20 determinative of its beneficial ownership as at the date of Mr. Leonard's death? So you see where the court is pointed now towards answering this question, because Mr. Morey is claiming that the funds are his.
Mhm.
But this was not how the issues were identified in the courts below. There it appears to have been common ground that upon Mr. Leonard's death, Mr. Morey held the money on resulting trust for Mr. Leonard's estate, unless he could prove, the burden being on him, that Mr. Leonard had intended to make a gift of the money to him. The Chief Justice decided at the trial that Mr. Morey had failed to discharge this burden, and so the Court of Appeal took the opposite view. So you had one court saying that Leonard can have it, one court saying he couldn't have it. So Mr. Leonard was a successful businessman in his mid-90s by 2009. By his will, dated 19th of October 2009, he gave his home in Nassau to Mr. Morey. Out of the rest of his estate, including cash and banks, he gave a number of pecuniary legacies, including $55,000 to Mr. Morey and $75,000 each to the Salvation Army and the Humane Society. He divided the residue equally between Mr. Morey, Dorothy Jack, and Norman Whitlock. He divided the residue. In the event of a shortfall for the payment of legacies, he specified that the request of the Salvation Army and the Humane Society should abate first, so as to enable payment of the other legacies in full. The executors named in the will were Mr. Morey and a lawyer named Mr. Pinder. So on the 20th of November 2009, so this is 1 month after he wrote the will, Mr. Leonard and Mr. Morey visited FCIB for what the judges described as the purpose of joining Mr. Morey to Mr. Leonard's existing bank accounts. There is some uncertainty whether Mr. Leonard had one or more accounts at FCIB. In any event, Mr. Morey was to be joined to all such accounts. Nothing turns on whether there was one or more, and like the judge and the parties, the board will refer to the accounts or account in the singular. The mechanism adopted was for both Mr. Leonard and Mr. Moray to sign account opening forms as joint account holders on FCIB's standard forms for that purpose. The substantial balance then standing to the credit of what had until then been Mr. Leonard's sole account was thereafter treated as standing to the credit of the newly opened joint account. So in paragraph 6, I highlighted, no evidence was called from any bank official about that event, nor was there any documentary record of what took place other than the account opening forms themselves. The judge did not accept Mr. Moray's evidence regarding it as self-serving. The account opening form signed by Mr. Leonard also contained in a box stated state purpose of account. A manuscript note to pay utilities, which it was common ground, had been made by an unidentified bank official. Both forms contain immediately above Mr. Leonard's and Mr. Moray's respective signatures a declaration in the following terms. I hereby declare that the information provided by me in this application is correct and complete to the best of my knowledge, and that I have received, read, understood, and accepted the agreement and the disclosure documentation and shall be bound by its terms. So section 5 included at clause 20 the provisions as to joint tenancy set out above. So on the 11th of March, so Mr. Leonard died on the 18th of February, 2010. So he died November, December, 3 months after, at which time the joint account was in credit in the amount of $190,000. On the 11th of March, 2010, Mr. Moray attended FCIB and reconstituted the former joint account with Mr. Leonard as a joint account between himself and his wife. Meanwhile, the executor, Mr. Pinder, set about preparing for the administration of Mr. Leonard's estate, and in particular for the obtaining of probate. He obtained information from his co-executor, Mr. Moray, on the 30th of March, which he said included being told that the assets of the estate, including the $190,000 at FCIB. Later, on the 9th of June, 2010, Mr. Pinder and Mr. Moray signed the executor's oath for the purposes of obtaining probate. The annex schedule makes reference to $100,000 held at FCIB. This may have just been a misprint for the $190,000. Because otherwise, the schedule, they say, couldn't be reconciled. So on July 2013, each of Mr. Moray's fellow residuary beneficiaries, that's Ms. Jack and Mr. Whitlock, issued originating summons in administration of Mr. Leonard's estate, seeking declarations that the balance held in the joint account of Mr. Leonard's death was thereafter held by Mr. Moray on trust for the 3 residuary beneficiaries, rather than having passed to Mr. Moray by survivorship. You following?
Yeah.
Okay. So Mr. Moray wants the whole 190. And the other beneficiary says no, it should be split between the residual beneficiaries. Again, the judge say in paragraph 15, no one had been, because he expressed surprise that no one had been called to give evidence from FCIB, either as to a recollection of the transaction in question or as to the bank's usual practice when opening joint accounts. Paragraph 16, he said, he concluded that a number of factors, including the quote, to pay utilities notation on the account opening form, the terms of Mr. Leonard's recently made will dealing with cash at banks, and Mr. Moray's information to Mr. Pinder about the joint account money being an asset of the estate made it more likely than not that Mr. Leonard had no intention to make a gift to Mr. Moray, but had added him to the account in his old age simply to assist him to pay his bills. So let's go to now where the Privy Councils decide how they're going to come to their conclusion. So he says in paragraph 20, there are a large number of dicta from eminent courts around the common law, including Australia, Canada, the Caribbean, England, Hong Kong, Ireland, and Singapore, about the principles to be applied for the resolution of disputes about the beneficial ownership of money held on joint account at a bank. Under the common law, legal title to property in co-ownership can only be joint title. Survivorship, that is the devolution of those legal rights upon the survivor or survivors of joint owners, is an inevitable, indeed inherent aspect of joint legal title. In sharp contrast, joint ownership, often called joint tenancy, with a right of survivorship, is only one of numerous ways in which property may be co-owned beneficially. Then he went through quite a few cases. He says in paragraph 27, if the question is asked in relation to money held in a joint bank account, what instrument might be thought to constitute the appropriate document where a binding declaration as to beneficial interest might be expected to be found? The obvious answer lies in the account opening document. This is because it sets out the contract pursuant to which the choice in action which constitutes the relevant property is created. So everything goes back to the contract. He says, furthermore, if, as in this case, the account opening document contains an express assignment by each account holder to the two of them jointly of any money separately owned by that account holder, it does indeed constitute a document of transfer, even in the strict sense. So he says in 29, the application of this simple analysis based upon established principles about the ascertainment of beneficial interests in co-owned property leads the board to this conclusion, that where two or more holders of a joint account all sign an account opening document or separately sign identical documents, which on their true construction declare or set out their respective beneficial interest in the property constituted by the account, meaning the money in the account, then those are the beneficial interests of the account holders, pending any subsequent variation of them by agreement or otherwise. So let me see if I could take you to, we went through some other cases. Trying to reach the, get to you the. Because he gave you the, in here, he gives you the general thing on joint accounts. Hold on, let me see if I get. Okay, paragraph 42,
Yeah.
paragraph 42,
Okay.
down almost to the end.
Mhm.
Says, in the board's view, that's the Privy Council, there can be no general rule that account agreements are only about legal title or only about the relationship between the account holders and the bank, rather than their relationship as beneficial owners, inter se. In each case, it will depend upon the true construction of the relevant agreement. If either of the decisions of the Supreme Court of Canada in Niles versus Lake and Pecori versus Pecori are to be read as deciding that there is such a general rule, then the board agrees with the submission of counsel for Mr. Morey that the common law of the Bahamas contains no such rule. Reference in this context is frequently made to Russell versus Scott, joint account decision of the High Court of Australia, in which a presumption of resulting trust in favor of the deceased account holder was rebutted. There is, in the joint judgment of Dixon and Evatt, a well-known and, in the board's view, entirely accurate description of the way in which the contract between the bank and the account holders creates a choice in action which constitutes the property in issue. There was nothing in that case about the terms of the contract between the bank and its customers constituting a declaration or statement as to the beneficial interest in the account. Unsurprisingly, therefore, the High Court had recourse to questions of intention and resulting trust in concluding that the survivor had obtained a beneficial interest in the joint account. So he says in 45, it is fair comment that reading the common law authorities about beneficial ownership in relation to joint bank accounts as a whole, there emerges a general impression that where the deceased account holder is the contributor of the money, the approach which requires the survivor to discharge the burden of proving an intent to benefit him, in which account opening documents play a purely evidential role in the search for subjective intention, has been widely adopted. But with the exceptions of Arso versus Coots and Niles versus Lake and Saylor versus Marsden cases, none of them appears to come near to addressing the question arising in this case, where there is allegedly clear declaration as to beneficial interest in the account opening agreement between the joint account holders and the bank. So don't forget now, Mr. Morey is arguing that the 190,000 is his. So he says at page 50, paragraph 50. Let me see, should I do 50 or 49? 50. This is therefore a case in which two holders of a joint account have, by an agreement with the bank to which they were both parties, expressly settled above their signature a declaration as to the beneficial interest in that joint account, which, on its true construction, provides for any balance on the account to be beneficial property of the survivor upon the death of the other account holder, regardless who contributed the money to the credit of the account before that date. It is in the board's view, a case in which there was no need to conduct an open-ended factual analysis as to the subjective intent of Mr. Leonard, since the account opening forms signed by him and Mr. Morey were, by themselves, dispositive of the beneficial interest in that account, subject to any contrary agreement or later variation, and there was none. Had the matter turned on such a factual analysis, there would, in the board's view, have been much force in the appellant's submission that the analysis conducted by the trial judge should not have been disturbed by the Court of Appeal. But for the reasons given above, the Court of Appeal's decision was correct. It was based upon a sound perception as to the meaning of Clause 20, with which the board agrees. The board therefore humbly advised Her Majesty that this appeal should be dismissed. It is understood that in these circumstances, issue number 4 into cost does not arise. Accordingly, subject to the submissions received within 28 days of this judgment, costs before the board will follow the event. He says in 47, on this issue, the board respectively agrees with the Court of Appeal. Clause 20 defaults to be construed in its context in the standard form of joint account agreement prepared for FCIB for use by private customers seeking to open joint accounts in the Bahamas in the 21st century. In the board's view, the key phrases are joint tenancy, are joint property with the right of survivorship, and if one of us dies, all money in the account automatically becomes the property of the other account holders. The meaning of those phrases is to be ascertained by reference to an objective assessment as to what reasonable Bahamian private customers of a bank would think that they meant. Private customers of a bank, whether in the Bahamas or elsewhere in the common law world, do not go around like lawyers thinking constantly of distinctions between legal title and beneficial ownership when contemplating the ownership of property. Even to a lawyer, clause 20, which would stand out, would be the opening words, joint tenancy. There would be no need to make express provision by clause 20 merely in relation to the bare legal title, which would be held jointly in any event. Whereas beneficial ownership might be as joint tenants or tenants in common or in some other form. Furthermore, the phrase, unless otherwise agreed in writing, can only have been about beneficial ownership, since there is only one form of joint legal title, whatever the parties may otherwise purport to agree. So thus, in the board's view, even a legally qualified intending customer of FCIB would regard clause 20 as therefore a purpose, namely to deal with beneficial ownership.
Question.
Yes.
So so the bank have one standard form, one standard contract for joint account. So when you open a joint account and you have stipulations, does the customer have to do that elsewhere or they could do that with the bank? When I
Okay.
say elsewhere, let's say we draw up our stipulations with our lawyer. Do we take that with us when we open up a joint account? Or can we stipulate those? We could say to the bank, listen, this is a joint account, but this is what I want done.
Oh, okay. So your question then goes to paragraph 84. This is where the dissenting judges, they didn't agree with that decision. They say, I turn to the banking agreement in the present case. It was a document headed Personal Account and Services Application. The first page had a number of printed boxes in which were inserted in handwriting the name and other details of the first sole applicant, namely Mr. Leonard. In the box headed State Purpose of Account, there was inserted to pay utilities. The second page provided similar boxes for information on the joint applicant, which were filled in with the name and details of Mr. Morey. There followed 1.5 pages of 23 closely printed terms, covering such items as basic terms, security, overdraft, jurisdiction. Clause 20, which is directly an issue in this case, read, and we read that already, joint tenant.
Okay.
Although there were some differences in the language of the clause in the case that the judges used, which was Niles versus Lake, and that of the clause in the present case, Mr. Parker, rightly in my view, does not suggest that the differences were material in respect of the distinction between legal and beneficial interests. He relies on some factual differences in the surrounding circumstances and in the relationships of the parties. However, they can have no direct relevance to the issue of construction, which turns on the objective consideration of the document itself. Mr. Parker is driven to argue that Niles versus Lake was wrongly decided. For the reasons given above, I do not agree. Like the Canadian court in that case, I see nothing in the language of clause 20 to indicate an intention to deal with beneficial interests, rather than simply spell out the consequences of holding a legal estate in a joint bank account. The majority suggests that private customers do not go around thinking constantly of distinctions between legal title and beneficial ownership. This may be true, But neither do ordinary people use language like that in clause 20 to make a personal gift. In any event, the meaning of such a standard clause cannot vary depending on the degree of sophistication or legal understanding of individual customers. It is designed to be a part of a set of standard conditions and as such to have a standard meaning. Further, the particular clause cannot be read in isolation from the consideration of the purpose of the agreement as a whole and the place of the clause within it, as understood by a reasonable observer. There is no doubt that it was a tripartite agreement binding all three parties, the bank and each of its clients, and that it constituted a choice in action in which each of the account holders had an interest. But what was the agreement for? Was it an agreement designed simply to provide a mechanism for the holding and handling of money by the customers and to settle the legal relationship between them and the bank? Or was it intended to go further and to constitute a substantial gift from one customer to the other? That is a straightforward and common sense distinction which does not require sophisticated understanding of banking law. The first pointer to the answer is that the clause was part of a standard form prepared by the bank with no inputs from the customer. The natural assumption is that it was designed to deal with matters in which the bank was concerned, that is, in legal, not beneficial interests. As Rand J. observed in Nile versus Lake, it is difficult to see any reason for the bank to use its standard terms to dictate to its customers how to dispose of the beneficial interest in funds held in its accounts. From the customer's point of view, the primary purpose of a bank account is as a mechanism to hold and handle money. As I have said, it is not the sort of instrument one would expect to be used to make a generous gift. In this case, a half share in a fund of some $190,000 to a personal friend. In any event, any suggestion that this was the purpose of the arrangement was negated, in my view, by the specific indication of the purpose of the account, not to make a substantial gift, but for a more mundane purpose, to pay utilities. In that respect, it is a stronger case than Niles versus Lake, where the banking agreement contained no such indication. In general, such handwritten additions to a standard form of contract should bear added weight, inasmuch as the written words are the immediate language and terms selected by parties themselves for the expression of their meaning. So he concluded, for these reasons, in my view, in respectful disagreement with the majority, the appeal should be allowed and the decision of the Chief Justice restored. So you see, the dissenting judge said you should take into consideration that writing that was put on the application form, that he was only added to the account to pay bills. Versus his argument that the whole $190,000 belong. And these matters do go to court. So my question is, when persons fill out these joint accounts, is there a box that states the reason? Because in this case, they said someone in the bank squiggled that on the form.
Not for our institution. When we open joint accounts, it has the in the AFDS, the account for deposit services. So that would be like their terms and conditions that they assign to say, you know, they will take full responsibility for the account. So for ours, it's just the primary person. There's a box for the primary. There's 4 boxes, because I guess up to 4 persons can go on one account as joint holders. So we just let them sign, and then that's it. But it doesn't really state the purpose of the account, which is why I said, you know, when we open joint accounts, if one person dies, the other person has full access to the account. It's their account until, you know, they decide to, I guess, terminate the contract with us.
Yeah. So in essence, what the Privy Council said was that a surviving joint bank account holder is entitled to the beneficial interest in the monies held, even when the deceased had paid the entirety of the funds into the account, absent special circumstances such as fraud.
Mhm.
So monies held in joint bank accounts are subject to any arrangements set out in the accounts documentation. So that's a good case for you to sit
Yeah.
down and read. And I had another one here. Let me see if they gave the name of the case. Okay, it was this one, 61. No, there's plenty cases. Jones versus Maynard. Okay, it says joint accounts, beneficial interest. Identifying the person who is beneficially entitled to the rights over the account depends very much on the particular circumstances of each case. If the joint account credit balance results from payments made by each of the account holders, then the right to those funds will be regarded as accruing beneficially to each of them during their lifetime, either as tenants in common or in proportion to their contribution to the original fund, or as joint tenants. Like the common law position, joint equitable ownership of the right to the account funds carries with it a right of survivorship, so that upon the death of one account holder, the entire beneficial interest will vest in the surviving account holder, leaving the deceased account holder's estate without any equivalent claim. In other words, in this situation, the beneficial title follows legal title. In contrast, where the beneficial entitlement to the choice in action representing the account is held in common, the remaining account holder has no automatic right of survivorship. Accordingly, as considered in the following paragraphs, the surviving account holder will have to demonstrate that the deceased intended either to make a gift of his beneficial entitlement during his lifetime or to confer an express right of survivorship upon his death. So I think this was the latest case I was able to find on this section. So it says that the clauses in the joint account opening documents that deal with beneficial ownership would be definitive authority in the case of a dispute, in principle, regardless of the intent of the parties. But it said that this decision is only persuasive on English cases. So in that case, Mr. Morey got the funds. Now, it may have been different if a representative from FCIB had given evidence as to why they had put that indication there that it was to pay utilities. So in your notes, we went on to talk about a joint account mandate can terminate or be canceled. Of course, when there's a dispute between the parties, when the parties give written instructions, or as the usual terms for cancellation on death, bankruptcy, or mental incapacity. Partnership accounts. A partnership is a business relationship with two or more owners, and partnerships are generally governed by the provisions of the Partnership Act. Every partner is considered an agent to the partnership and has the authority to bind all partners. And a partnership is similar to a sole proprietorship in that the legal and financial liabilities of the partnership extend beyond the partnership actually to the individual partners and their personal assets. So banks who transact or do business with a partner will not be prevented from legally binding the partnership or the other partners. Once the partner's action is done in the partnership name and within their actual authority, whether that authority be actual or apparent or implied. Overall, a partner's liability is joint liability for any debts and obligations of the partnership, and joint and several for any torts. Creditors can sue or pursue partners individually or the partnership generally to satisfy any obligations. And partners are liable for the actions of the other partners where such actions were done on behalf of the partnership or in the partnership's name. So notwithstanding any joint liability for debts and obligation by partners, banks normally require partners to be jointly and severally liable in opening partnership accounts. And that's in order to protect their interests. Of course, proper due diligence has to be carried out on all of the partners. And if the partners are existing account holders, the usual due diligence requirements may be waived if the documents are valid. The partnership account should be open in the name of all the partners, and the bank that mandate will direct how the partnership account will be operated, and of course, who has the relevant signing authority. The mandate should make it clear that the account will be operated under joint and several liability. And when borrowing, banks customarily require the authority of all the partners for non-trading partnerships. So there is an implied authority of common law to borrow. Under a partnership, the retirement, the removal, or death of a partner dissolves the partnership formed under the Partnership Act or partnership articles. If a partner retires and the partnership wishes to continue under the existing name, the bank ordinarily requires a new mandate to be signed by the remaining partners. If the account is in credit, the account may continue to operate, providing that the remaining partners consent to the checks written by the retiring partner. And to avoid the rule in Clayton's case, operating to its detriment, the bank should ensure that the partnership account is closed on the resignation of a partner and open a new account with the remaining partners. And of course, the same principles apply when a partner dies and the partnership is effectively dissolved. Now, when you open an account for a company is a legal person. It has its own identity, its own obligations, and the company itself is limited. It could be by shares or it could be by guarantee. The company itself is separate from the shareholders. So in the Bahamas, a company can be incorporated either under the Companies Act or under the International Business Companies Act. Both acts has different requirements for statutory filing. So if you have a company that wants to open an account, what's required? What do you need to open an account for a company? Lorenza.
Repeat it, please.
What documents do you need to open an account for a company?
I guess a small business or like a large scale company like Atlantis or one of those.
like Atlantis. Small
Um,
scale companies, those trading hours, those are sole proprietorships.
okay. Um, I don't really know, but I'll say I guess basically, of course, the business license. Um, I guess the KYC documents that be like the IDs of all the board members. Um, I guess I don't know. I don't know much about the large scale companies.
Okay, all right. So
I'd like to add, would a business plan be necessary?
if they're borrowing,
Hmm.
no. Okay, so a company is a legal person. How does a company become a person? A company becomes a person when it takes the step to incorporate a company. So the first thing they do is they reserve a name. After they reserve the name, the lawyer prepares its memorandum and articles of association. The memorandum and articles of association is what you call the constitution of the company. It says how that company is to be run on a day-to-day basis. Once the memo and articles are drafted and filed with the Registrar General and the appropriate fees are paid, you are issued a certificate of incorporation. That document, that one little certificate, says that you are now a company and you can do business. So the most important document you need when a company comes in is its certificate of incorporation. That proves to you that they are a company, duly licensed. If they are going to be doing business like seeking funding, a loan facility, you want their memo and articles of association. Why? Because it tells you what the company can and cannot do, one, and it also tells you who has the authority to bind the company. So that's 3 documents now. Of course, yes, you need a copy of their business license. Now, if the company was incorporated in the last 3 to 6 months, you do not need a certificate of good standing. But if the company was in existence for the last 3, 5, 10 years, in addition to those 3 documents, certificate of good standing, articles and memorandum of association, you need to request a certificate of good standing from the Registrar General. That tells you that all of his fees have been paid and all of his filings have been submitted to the Registrar General. In addition to that, you normally ask for a copy of its registers. So you want a register, it's a form, and it states the names of all of the directors of the company. Then it states all of the officers of the company. You would then ask for a copy of the board resolution authorizing the company to open an account at your bank. And if it is an operating company, like Bahama or Commonwealth Brewery, any of those, every year you would ask for a copy of their authorized signatory list, because that tells you who is authorized to sign on behalf of the company.
That goes for schools and stuff as well.
Schools,
Yeah, like government schools, like CV Bethel or Yellow Elder Primary or one of them.
I don't know if the schools actually have memorandum and articles, because those are government facilities. I don't know if they stand on their own.
Okay, so it's more for private entities then.
But you don't call them private. Because a company like the brewery is a public company. But you also can have private companies. Like you can incorporate a company to do it, and that'll be private because you haven't gone on the market for investors. That's called public. Whenever you go on the market to seek investors in your company moves from private to public. So if they are government school, then I would assume that they all fall under the umbrella of the government of the Bahamas. Because I'm not aware of each one of the government school having its own authority to do certain things. Most likely that would come from the Ministry of Finance. And then you have unincorporated clubs and societies. Now, for a company, remember, a company is a separate legal entity. It is separate from its shareholders and from its directors. It can sue and be sued. A company is like a person. When it comes to unincorporated clubs and societies, they have bylaws. And they, again, if they're opening a bank account, they will have a resolution. And because they're not formalized like a company, they normally have some kind of personal guarantee. Because the bank needs to know who to sue in the event if there is a lending facility. Now, we all know the bank has the duty to maintain an accurate record of a customer's transactions. And under common law, there's no obligation to check your statements. So who read the case of McCushla versus Scotiabank and then Scotiabank versus McCushla?
I skimmed over both of them.
I scammed the
All right, so let's start with the first skimmer. Let's start with McCushla versus Scotiabank. Let's see what the courts had to say. All right, let's go. For those who didn't read, because I've been saying for 3 weeks, read it, right? What was the issue? Why did she go to court?
She basically went to court because she said that there were unauthorized withdrawals on her account. She said that some of the withdrawals were over the limit of the ATM withdrawal. She said that the bank also failed to notify of the fraudulent transactions,
Mm-hmm.
and that the bank didn't provide her with statements.
Okay.
So that she could have, I guess, reviewed or monitored her account. And I don't think online banking wasn't as prevalent as now. So it wasn't where she had access to check her account.
How did the bank refute this?
How did
yeah.
Go-
The
again?
bank, the bank took a different position. What did the bank say?
The bank's argument was that when she signed since it was Scotiabank, we call it the AFDS. Basically when she signed, she took ownership for the account, and hosting the account means, checking your account frequently, making sure that everything is in line in terms of like ensuring banking is done in a proper manner, making sure that the account is being used for yourself and what's not. The bank did own up to some of the charges. I mean, to some of the things that they didn't do. However, certain things in terms of like checking your account, that's the onus was on the customer.
So on what grounds did the court award her the sum she was asking for? How did they come to the conclusion that she should be awarded the sum that she asked for?
The court granted her because, like she said, the bank didn't notify her in terms of like when the withdrawals were being done on the account. And she also said that the withdrawal amounts, I think at the time it was only 1,000. She said they were exceeding that amount, and that an unauthorized debit card was issued from her account.
Okay, so in banking law, what did the bank do wrong? What was the bank? What was the bank's duty?
The bank was supposed to issue statements, showcase having a clear what's that, like a transactional history of the account, making sure that everything is clear to the customer. What else? The bank was also supposed to
She kept arguing that she never used an ATM machine to withdraw off her account.
Correct.
And that she was not on the island when these funds were withdrawn.
Right. Yes. That she was away.
Mm-hmm. And she didn't have a passport because that was discontinued.
Yes, ma'am.
So she argued that you were expecting me to check my account without giving me any statements. And the argument was, everybody knows that you can go online and check your account. So in this instance, the court said, Scotiabank, updating of the passbook, which had allowed the plaintiff to monitor her account without reasonable notification to her. You agree with that? That the bank took away the updating of the passbook? Was it that the bank took away the passbook? Or it had to do with the changing of time? Just like how we're writing about the doing the research question on the checks.
That's the changing of time.
It's changing of time.
Yeah.
Yes, there are common law principles that the duty of the bank has a duty to maintain an accurate record of a customer's transaction. And the customer under common law has no obligation to check the accuracy of those statements. But times have changed. So what happened when Scotiabank appealed?
Miss Archie, you asked what happened when Scotiabank appealed.
Mm-hmm.
Basically from my knowledge of it, they basically stood on the grounds that it isn't really the duty of the bank to be constantly checking the customer's account. It's really the duty of the customer when they would have signed the contract to monitor all transactions on their account. I assume is their responsibility.
Let me see how he put it. Let me see how he put it. Let's see. I'm trying to see if I have it highlighted here. Let's see, paragraph 43. 43, I have 33, 43, 36. He said, but it appears that the respondent's case in contract was that in breach of contract, the bank honored withdrawals of monies from her account, which were not made by a card issued to her by the bank. The only evidence in support of that claim was the evidence of the respondent that she did not use her card and that she never used her card to withdraw monies from an ATM. She said that she never gave her card to anyone, nor did she give her PIN number to anyone. However, the evidence also is that she had lost or misplaced her card for periods of time. The evidence is also consistent with the fact that someone else may have used her card and PIN number to withdraw monies. The judge did not find as a fact that the withdrawals were made otherwise than by use of the card. There is no evidence that there was skimming, and the judge did not find as a fact that there was skimming. The respondent speculated that this may have been done, but the testimony from bank officials was that the withdrawals were made by the card issued to respondent using her PIN. The respondent alleges that this must be false, as withdrawals were made from machines in New Providence when she had the card with her in New York, as evidenced by the purchases that she made in New York during that period. Regrettably, the judge did not analyze that evidence and make any specific finding that the respondent could have used the card on those dates. However, having regard to the dates, the evidence was consistent with the use of the card on the day the respondent left for New York and on the day that she arrived from New York. So in short, the plaintiff has led no evidence that the withdrawals were made by a card other than her own. And as I said, the judge did not expressly make that finding. Moreover, the respondent did not bring to the attention of the bank that any withdrawals were improperly made until well after the withdrawals had taken place. Although the respondent could monitor movements on her account by accessing that information from the ATM machines, she chose to only monitor her account when she went into a branch to withdraw monies. Indeed, as the trial judge said in paragraph 13 of his judgment, the respondent, quote, was aware that there were other ways of receiving balances, but said that the way she heavily relied on had ceased, but couldn't recall when the bank stopped updating the passbooks, end quote. The evidence from the ban was to effect that the bank's policy of not updating passbook was in 2016. In a term of the Scotia card holders agreement, that the respondents would, quote, regularly update your passbook and check your account statements and balances, to verify all transactions have properly recorded. The evidence is that the respondent between September 2015 and February 2016 made no effort to verify any account statement. The respondent argues that she did not and could not verify as she had no account statements from the bank and that the bank had advised her that it was discontinuing updating passbooks for deposit accounts. In my judgment, that is too restrictive an interpretation of that provision. The respondent, like any cardholder, can obtain information about their account by many means, including using the card at an ATM machine. The obligation to check account statements and balances must include an obligation to check them through use of the ABM machines. As I noted earlier, the respondent acknowledged that she was aware that she could check balances by other means. So he says in paragraph 100 and 101, the judge said, the defendant took away the opportunity for the plaintiff to keep abreast and monitor unauthorized transactions on her account. Despite the PFSA containing a clause which placed an obligation on the defendant to notify the plaintiff of any additions or changes to the terms and conditions of the PFSA. No evidence was led by the defendant, which demonstrated that any reasonable notice was given to the plaintiff, notifying her that it was no longer possible to update her passbook, which was the only way she would have discovered the unauthorized transaction. However, there were transactions on the ATM card from September 2015 to February 2016, not carried out by the plaintiff. So you see, times had changed. And I think in her defense, she slipped by saying she knew that there were other ways that she could have checked her balances. And then she wasn't able to prove what clauses of the contract that the bank had breached. And she couldn't show any evidence that the withdrawals were made otherwise than through the card, which the bank issued to her using her PIN. So remember, banking law is based on, like we said in the second class, the third class is based on contract law principles. So if you're claiming a breach of contract, you have to be able to give evidence as to what provision in the PFSA the bank had breached. He says in paragraph 52, the duty to monitor the respondent's account, the respondent's claim is imposed by the Financial Transaction Reporting Act. Again, I point out that there is no pleaded claim based upon a breach of statutory duty under the FTRA. Indeed, no claim can be based upon the 2018 statute, which came into effect in 2018, after these impugned withdrawals had taken place. There was a 2001 statute in effect in 2015 and 2016, but the judge has not based any liability on that statute. Moreover, the provisions of sections 5 and 12 found in the 2018 statute, upon which the judge relied, are not found in the 2001 statute. So you see, it went all awry. And so he says in paragraph 59, there is simply no evidential basis for finding that the bank in this case was put on inquiry that any attempt was being made to improperly withdraw monies from the respondent's account prior to February 2016, when the respondent first alerted the bank that her account balance was wrong and that she did not make any withdrawals since September 2015. The withdrawals were being made using her card with her PIN. What that speaks to then? What's one of the duties of the customer?
Can you repeat it, please?
Now, paragraph 59. Is he says here that she didn't
Could
produce
you read it
any.
again, Ms. Archer?
Okay, paragraph 59. The judge is saying that she didn't give any evidence for finding that the bank, in this case, was put on inquiry that any attempt was being made to improperly withdraw monies from her account prior to 2016. And I was asking you, what duty is that of the customer?
Is it the one where the customer must report any fraudulent transaction on their account?
Yes. So he's saying here that the respondent first alerted the bank that her account balance was wrong in February 2016, even though withdrawals were made in 2015. And the withdrawals were made using her PIN. Then he says, after withdrawals made after February 2016, when the respondent was issued a new card, the respondent has led no evidence which would justify the bank being on inquiry that her card was again being improperly used. Remember now, we move from passbook to cards. Everybody knows when you have an ATM card, you can go to the machine and check your balances. If you put your card in your phone and sync it to the app, then what happens every time there's a withdrawal? What happens? Doesn't
You're notified of the withdrawal.
exactly. And you're asked if you made it. If you didn't make it, then tell me. And then at the end of every week, you get your balances automatically. So you see where the judge is heading with this. He said, again, there was no evidence that she monitored her account between February 2016 and November 2016. So she knew she had withdrawals made on her account from September 2015. She alerted the bank. Then more withdrawals were made in 2016, but you were still not monitoring your account. Is that not a breach of her duty? So he says she did not bring to the attention of the bank that withdrawals were again being made improperly. Assuming that the withdrawals were improperly made, the issue is whether the respondent has made a case that the loss was caused by some breach of a term, express or implied, in her agreements with the bank, or as a result of some duty and tort owed by the bank to her. Because that's what she has to prove, that the bank breaches duty or the bank was negligent. So in the absence of any evidence that there was a skimming or another card being used by the bank, there is, in my judgment, simply no basis in law in holding the bank liable for the loss. In her agreement with the bank, the respondent accepted a responsibility to regularly monitor her account and to immediately report any improper transactions on her account. She had the ability to do so, but did not do so. It was that failure which caused the loss. There was simply no evidential basis for the judge to find liability on the part of the bank on the respondent's pleaded case. And so she lost. She lost the case. So you see how in the Court of Appeals, they went back to the duty of the bank and the duty of the customer, and looking at, again, the express terms of the agreement. So yes, in common law, there are duties of the customer and duties of the bank. But then you have a contract that stipulated what her duty was. And if she wanted to sue the bank for her loss, she had to be able to prove that there was a breach of the contract. And she couldn't prove there was a breach of the contract because the bank couldn't prove that there was a skimming that happened to her account. Added to that, that she did not fulfill her duty in monitoring the account in a manner in which it should have been done and reporting the losses and being vigilant when it happened for a second time. So for those who didn't read it, you can read it, because it gives you a good example of the duties of the customer and the duties of the bank, and looking at the actual contract, express and implied terms. Any questions?
No, ma'am.
Okay. And then after that, I just talk about refunds and excess, and you could read that. And then, of course, credit references. And in order to get a reference, of course, you need the customer's express consent to do that, because you have to bear in mind the duty of confidentiality. So next week, we're gonna look at money laundering. And I know you all always have your annual training, so that should be a good class, correct? Yes?
Yeah.
No, y'all sound like y'all so tired. Okay, so what I'm gonna do is I will email to you all tomorrow the research question that will be worth 25 points towards your final exam. And I'll also give you the date of the final exam. I have made a note, no multiple choice. And you will have your grades. I'll send it to you individually before next class. Okay,
Yes, ma'am.
all right. So enjoy the rest of your subtropical storm. You have work tomorrow or no work?
No work for banks.
Oh. So what if the storm move completely out of,
I guess they'll let us know by tonight before 12 a.m.
and they'll say, what you mean before 12 a.m.? They can tell you at 6 a.m.
They can't tell us it's 6 a.m.
Ah, I'd be sleeping. That
short
would make no
notice.
sense. Yeah, that's too short notice.
Why you commuting to work? You coming by train?
No, I
No, but
I wouldn't be prepared. I wouldn't mentally be
Right.
prepared, because if I know I have work in the morning, I definitely wouldn't be going to sleep early for sure.
I'd
I
have
have
to
no reason to sleep early.
iron. We have other obligations that we have to tend
Yeah,
to before work.
you have family, etc. A lot of stuff to do.
I listen to all these things. Okay.
Yeah, for sure. My plan was going to go to sleep early tonight. I can assure that. So
We gonna be reading banking law?
yeah, for an hour or two. As soon as I mentally there.
All right, then. I'll
But
take that.
I have one question in regards
Go
to
ahead.
the results. Was any of the results, I would say, I don't want to
What do you
ask
mean?
any,
You mean
any,
about the midterm?
yeah.
I haven't marked it yet.
Oh, you haven't marked it yet?
No,
Okay, okay, okay.
I have it.
But
There's
you
some
haven't
students
marked it
who
as
have to,
yet.
yeah, some students have to take it. So on Tuesday, we could talk about it.
Okay, okay.
Yeah, don't stress. And then, like I said, if the grades are low, you get a supplement take-home exam.
Okay, that sounds good. So there's
Yeah.
25% you say in regards to our final exam. So that means, as it stands, we walk in the exam at 25%. So initially, That would be 25 of the 60 points, right? Or something, because the exam were at 60 points, right?
The final exam is 60%.
Yeah, so that would be 25% of the 60%, meaning we walk in and did the exam with I guess with the expectation of 35% of the written final.
No, why you get, what kind of number you get?
Okay, for demonstration, you said the final exam is 60%, right?
You get
Meaning
the,
if I get 100%, I'll get the full 60 towards my final grade, correct?
yes,
Okay, so there's 25 points that we're getting now for this research question, right?
mhm.
You say
Yeah,
that's
that's
25% of our final grade on the
no,
exam.
no. Yeah. So the exam is going to be marked out of 100.
Okay, so I already get 20, so 25. So even if I get, technically if I get a 50, 25% of that would bring me up to 75, basically.
Yeah. Yes.
No, but
Okay,
that's
okay,
that's
okay, okay.
25
So
points
I understand
provided
completely.
you. That's 25 points provided you do the assignment to achieve the full 25 points.
Of course, of course.
Yeah,
Right. So you could,
but if you didn't do the assignment and if you get 100%, you still get the full 60, correct?
yeah, but
What you mean? If you didn't do
yeah,
the
but the
assignment, then
passing
you
the
already
passing
lost
grade is
25
80.
points.
Exactly. So if I lost 25%, 25 points, that means I need to get up to 75% in the
And you
exam,
still,
right?
and you still fail the
Mhm.
class.
You can
And you
fail the
still fail the
class.
class.
Yes.
80% is the passing mark.
80% is in the passing mark.
Yes, it is.
The overall percentage of the class is 80%,
70. But you need about an
70%.
80. Right. But you have to have a good grade on the final exam to pass the class overall.
And what average? What would you consider a good grade? 80% and up?
Yes. This isn't
Okay. So
difficult. You all know this.
say again.
I said you all know this. When I read the midterm, I'll be able to tell you all generally where you're going wrong, if you are. So stop stressing now. Let me read them first, and then I can tell you all where you're going wrong. But remember, for the final, there is no contract question on the final. Everything
Okay.
relates to banking law. So don't stress yourself on that.
All right.
You stressing and getting a headache before we even start. And then you go in the final exam and then you go climb right up. So
Okay.
no, stay calm.
All right.
Okay.
All right.
All right. So have a good evening and please go and read some banking law now. You promised me.
Okay. Okay.
Okay.
Not now. No promises now. Maybe next 2-3 hours.
Okay. But
All right.
don't let us have a laugh next week Tuesday when y'all tell me, yeah, we had to go to work.
No, man, don't. That ain't no truth. Why you speaking that on us? Don't speak that.
I'm
Lord,
just
I
saying.
refuse that. No.
You all right then. We'll see for next week. All right.
Okay.
So look for my email on the research question. Okay.
Okay.
All right. Talk to you all later. All
Good evening.
right. Have a good evening.
Good night, good night.
Good night. Stay safe.
Bye. All right.